Hi, I'm James Snyder. I'm a business transactional attorney specializing in privacy with Kleindienst PC in San Diego, California. Today I'll be talking to you a bit about the California Consumer Privacy Act, or the CCPA as it is, and it was implemented in January of this year. And it really is the most robust and broadest data privacy set of laws for consumers' protection that's ever been implemented in the United States. It's very similar to Europe's GDPR, in fact. And what it requires is that California consumers have a broad spectrum of new rights that businesses actually have to inform them about, usually on their website if they have one. And those rights are things like what information does a business collect about someone, how it's used, who it's transferred to if they're third parties, where it is, and so forth. And the rights to consumers to actually have access to the information or have it deleted, opt out of the collection, and prohibit the sale if the businesses conduct the sale of third-party information. So the CCPA doesn't just apply to California-based businesses. It applies to any business that's doing business with California consumers. So if you collect, if you sell, if you share consumers' information in California, 50,000 or more in a year, or household information, or you have $25 or more million in annual revenue, then the CCPA applies to you. Doesn't matter if you're in California or not. So the CCPA is really impacting the digital landscape for businesses throughout the United States. And one of the major areas that it's impacting is with respect to digital cookies. So digital cookies are small files that are stored on your browser or your mobile application. And they really tell businesses who you are to a certain extent and what your digital practices are, what sort of behavior you engage in on your digital devices. And that is really being impacted by the CCPA. The cookies themselves can be used to really enhance your experience. You don't have to put login information when you go onto a website or tell it what sort of language you want to hear, but they're really used for businesses for marketing purposes. They're really marketing gold. You're on a particular website and days later on a different website, there's ad retargeting with use of cookies, and now you're being suggested or reminded to go back and buy the product you were looking at before. That sort of behavior now is sort of winding down. I think over time goes away because as consumers understand that they don't have to opt in, or they can opt out rather, from the use of their information, more and more they're doing that, and then businesses aren't allowed to sort of engage in that type of marketing. So businesses in particular that are impacted are those that engage in third-party behavioral profiling type practices. So businesses like Facebook and Google and LinkedIn that really sort of build a profile around your different types of digital experiences and activities, and then use that for other businesses to acquire it, to sort of suggest products to you, etc. Those sorts of practices are really being impacted by the advent of the CCPA, because as businesses tell you that you have the right to not allow them to use that data, consumers are opting out. I think over time cookies go away, and I think businesses have to find other ways of marketing, but for the time being, when you go to a website, you're seeing footers or wrappers that inform you of your rights, in some cases require you to opt in. California requires you the ability to opt out. And I think over time, probably everybody just has a wrapper that says opt in, and for businesses' ease across the board, that's probably what we'll see over time. I think some suggested best practices would be to really understand the data that you have, how you're using it, and so forth. Make sure that you update your websites and your policies. You have a very robust compliance program. You really chain your leadership and explain what the rules and requirements are, what the penalties are for not complying with the law, because the penalties can be quite stiff. Make sure your legal staff, if you have it, really is up to date with all of the rapidly changing data privacy laws in California, throughout the United States, or wherever you do business. And then really focus on your vendor contracts. Vendor contracts are going to be key, because it's not just good enough for you and your business to comply with the law, but your vendors have to as well. Go back through those vendor contracts, renegotiate them if you have to, and it's going to be the best way to try and comply with the law. Next time you're in San Diego, check out the Midway Museum. It's steps away from our beautiful offices in downtown San Diego, right on the water. If you've been there before, check it out again. They're always updating their exhibits. So I'm James Snyder. Thank you for listening. If you have questions or you need help with data privacy issues, whether it be the CCPA or anything else, I basically help businesses get business done. Anything from contract review to helping you get your commercial lease in place, helping you set up your website policies and procedures, negotiate with your contracts, vendors, helping with data privacy issues and the like. Love to help you out. Please give me a call or send me an email, and I'll hope I talk to you soon.